Good morning. This is the one where. All in all, my team just gave me a note here that I need to speak about the one where the laws or the law was vague but not impossible. This was actually a case from a number of years ago. What was happening in this case, it was Pakistan. Pakistan had a very interesting situation where, in this instance, the customer wanted to export things from Pakistan that was previously imported. However, what was happening in this instance is the law was, I would say, partially convoluted. So what happened was the customer came to us because two other consulting firms informed them that it's impossible to export previously imported goods from the country and that the law doesn't allow it. There is no way to do this. When we were tasked with the objective to review the law and determine whether it is possible as basically a second opinion. We were tasked with, okay, is this possible or not? We found if you look at the customs export policy of Pakistan, if you look at the export requirements, the general customs regulation, what was the situation in this instance and why the other consulting firms concluded or could have concluded that it is not possible at all is because there was a mismatch or let's say the law was vague and or convoluted. The law was unclear whether export of previously imported goods were possible. What does this mean? It means that on the import policies, there was clear requirements that had to be followed. But on the export policies, there were customs regulations, export policies that didn't make a clear provision for the law that had to be applied in this particular business case. So what happened is the client was importing service support equipment, which is generally not for sale. Well, in this instance, it was not for sale. And it had to bring these goods into the market in order to service support clients. So goods that were already sold, so under warranty. However, these goods remained in the market and became unusable and had to be exported. However, the law in itself didn't allow for that because under the policy, it only allowed for general normal export, provisions of repair and return, and it provided for an ability if the goods would be, broken, in which case none of these principles applied. So what do you do? What do you do when the law is vague, applicable, or let's say applicable, not fully applied, and on top of that vague? On top of this element, there was one article in the customs export policy that could potentially be interpreted as a potential match. So meaning one could say these goods were unused, old equipment, and therefore not required in the market anymore. However, what was a challenge was the export procedures required for normal export was not designed with this article in question for the specific goods in application. So in essence, the law was, I would say, not applicable. It was very difficult to apply. And that could be why the previous conclusion of other consulting companies were just saying, not possible, sorry. The actual matter of the fact was that it is possible, however, it is vague. And what had to be done is there had to be, in order to achieve the objective, one had to ensure that these laws came together and that the institutions under these laws understand why these laws are written, how to apply the laws in the specific use case, and ultimately move towards making an export possible. So in this instance, after legal analysis, and complete legal review of not only the legislation, but the local practices and the way that the country operates, a clear way forward was found, because the legal analysis doesn't show it's not possible. It just shows the law is convoluted. The law is not designed to capture this situation. And the law does provide provision for escalation, for clarification, for consultation with the different authorities. And once you understand that, a clear path was forward. And in this instance, it was an export of about 32 million US dollar of equipment. So if you are looking at that magnitude of export and the value of the equipment in its unused form is 32 million, therefore its potential production form, the value may potentially be much higher. And therefore, ultimately, finding the right export procedures to test whether these unused equipment that have been in the market for several years is still valid. It's important to explain to the authorities this procedure. But to have that, you need the right legal analysis, the right legal interpretation, and the clear path forward. And ultimately, it came to the conclusion that it was not impossible. The law was just vague. So when you find yourself in a position where the law is vague, look at the law from all angles and ensure that you understand the practical application of the law, not just the letter of the word. If you enjoy this type of content, we do have a network, tradenetwork.blueblox.ch, or click the link below and you can come and follow us. All this content is made available where you can learn and you can grow with other trade experts in the market or people that's interested in trade. Come and join our trade network. It is free. And we would love to have you on the journey to learn more about how to trade correctly and compliantly. Wish you a great day. Bye.